Okay, welcome back to part 2 of chapter 5. We're going to start out with just a refresher here on the Bill of Rights. I've reiterated this before, and I know this has been mentioned in your textbook several times, but the Bill of Rights are the first 10 amendments to the Constitution, and they're designed to protect citizens against abuses, I should say all abuses, but the abuses of police power as well. We are more familiar today than we were 40 years ago with these rights due to the stronger case law enforcements, TV shows, movies, and legal intervention. We'll talk about number 2 here, which was the individual rights portion of this chapter. The Constitution is really a system of checks and balances among the legislative, executive, and judicial branches of government. The criminal justice system falls underneath the judicial branch, and all U.S. citizens have rights. And within the judicial branch, there is due process afforded to all for the protection of these rights. There are 3 areas of due process, and this is what we will talk about for the remainder of this chapter. The first one is evidence and investigation, which is also referred to as search and seizure. The second is arrest, and the third is interrogation. Now, all 3 of these areas have been addressed by many, many landmark cases, um, court cases. These cases help to clarify what we would perceive as the rules of the game or the procedural guidelines for our judicial system. The search and seizure, uh, if you can remember anything, really the Fourth Amendment focuses a lot on search and seizure. And we'll briefly cover the exclusionary rule. I'll discuss the Warren Court, which when I talk about a court, I'm talking about a Supreme Court, the Berger Court, and the Rehnquist Court. And what's the relevance of these courts? Well, actually, these separate Supreme Courts established many of our landmark court cases that have been applied to much of our procedure of law since really the 1950s, but I should say for the states since the 1950s and 60s. The exclusionary rule is a rule that holds really that if evidence is illegally seized by police, really on the failure to obtain warrants authorizing police to conduct a seizure, I should say, or a search, um, if the police then acquire evidence against somebody, that evidence will be excluded in court. So ultimately, in layman's terms, is if officers fail to obtain a search warrant or an arrest warrant, but primarily a search warrant, we'll say, and an officer somehow obtains illegally, I should say, evidence that is illegally obtained, it will be excluded. And that is based on the exclusionary rule, which was established uh, by the Supreme Court during landmark cases. It started actually in a federal case, Weeks v. U.S., back in 1914. And this was actually the first landmark case concerning search and seizure on the federal level. And I'm not going to get too much into the case itself because I'll send you this PowerPoint presentation. But really, there was incriminating evidence found against Mr. Weeks on the federal level. And that evidence was excluded from his case because of the officer's failure to obtain a proper warrant. Again, Weeks had been convicted in federal court. He appealed this case. He appealed the conviction actually up to the U.S. Supreme Court. Can't talk today. And it was overturned based on the illegal seizure, which ultimately formed the basis for our exclusionary rule. But now what? Well, now this precedent is established in the federal court and must be followed. But the problem really was that even though the precedent uh, is that even though the defendant committed the crime, he goes free due to the poor police procedure. So that's why it's very important for law enforcement to follow the guidelines appropriately. Get a warrant legally, properly, because if they don't, somebody who has committed a crime, maybe a very bad person, will ultimately go free because of a technicality, for lack of a better way to describe it. Now, there's also another doctrine called the fruit of the poisonous tree. And again, this was another federal case from 1920. Um, Mr. Silverthorne had failed to pay his federal taxes. And so the Fed searched the lumber company that he owned without a warrant and then seized his books. Well, what they had done was, instead of keeping the books, they had taken photographs of his books, which ultimately showed, it was evidence that showed that he had failed to pay his taxes. Well, since the books had been obtained illegally, the photographs themselves were considered the fruit of the poisonous tree. Um, they too were obtained illegally. You can't somehow take evidence from illegally obtained evidence and think that that's still going to be used against somebody for a conviction. And so, again, another reason to get a properly issued warrant, or, drafted warrant, and have it signed by a judge. Um, Now, what the fruit of the poisonous tree doctrine ultimately says is that illegally seized evidence cannot be used in a trial, and neither can the evidence that is used be used that derives from the illegal seizure. Again, like I said, the photographs. And then Mr. Silverthorne was set free. Now, the Warren Court, for us old dogs, the Warren Court is from the 1953 to 1969 era, and he was the Chief Justice of the court at the time. What Earl Warren did was he took the Weeks federal case and he applied it to the state level. Um, and the relevance of that is the exclusionary rule was, a rule obviously that wouldn't allow um, illegally obtained evidence in federal cases, but that still didn't cover the individual rights or the protection of citizens within the state uh, level, so to speak. So the case where the Justice Court applied this to states was the Mapp v. Ohio case. The Warren Court was famous for guaranteeing nationwide recognition of individual rights by all agencies at all levels of the criminal justice system. Mapp v. Ohio, Dolores, she was suspected of harboring a fugitive wanted in a bombing. And so when the Ohio police arrived at her house, she refused to allow entry, and they forced their way in anyway. I mean, bottom line, there was no protection for Miss Mapp because the landmark case only applied to federal cases at that time. And during the search, they discovered pornographic materials. She was ultimately arrested. And because the exclusionary rule was a federal ruling, as I said, state and local cops didn't believe that it applied to them. So, however, in the precedent-setting decision by the Warren Court, the appeal of Mapp's conviction was overturned. And what they did was the court applied the 14th Amendment, which is the due process guarantee, to that particular case. This mandated that all federal rulings also now applied to all state procedure as well. Let's talk about search incident to arrest. Another landmark case by the Warren Court is Schimmel v. California. And this really involved both arrest and search activities by police. Mr. Schimmel was convicted of burglary of a coin shop based on evidence that was gathered at his home when he was arrested. The officers had an arrest warrant, but they didn't have a search warrant. So what they did was, after they arrested him, the officers searched the entire house, attic, workshop, garage. The officers felt that they were justified because it was a search incident to an arrest. They did find the evidence of the burglary, and it was used against him, Mr. Schimmel, in court. Now, the attorney for Mr. Schimmel appealed the conviction based on the illegal search. It went up to the Supreme Court, and the court ruled that search was invalid because it had gone beyond the person, the subjects or the defendants or the suspect's immediate control. Some people would consider that what they call the wingspan. Thus, a search warrant must be obtained. So ultimately, here's the thing. If you have an arrest warrant to pick somebody up at their home, you can pick them up, arrest them, and then you hold the house until you get a search warrant signed by a judge. Then you can go back in the house and you can search it. Now, why is it relevant or okay to search the wingspan or the immediate control? Oftentimes that's for weapons, safety, public safety, etc. Um, so a previous federal case similar in nature was now being applied to all state cases. This is another, we've got a couple more courts, and so the individual rights era of the 50s and 60s started to swing more towards the conservative realm or public safety, if you will, starting in the 80s and 90s. And so a lot of these cases that were established and they were created as landmark cases almost to the benefit of the suspect in the 50s and 60s were now kind of being viewed differently um, by the Berger and Rehnquist court in the 80s and 90s. We started to see officers who would go to a house, pick somebody up with a search, or I'm sorry, an arrest warrant, or do a search with a search warrant that later on was found to have technical errors or problems. And officers had said, but I did this in good faith. So in 1984, there was a case brought to the Supreme Court, and eventually the good faith exception to the exclusionary rule was established. And I will go ahead and send this to you so you have a little bit more information on probable cause, US v. Leon. Now we talk a little bit about plain view doctrine, and what is it? Well, when officers have an opportunity to begin investigations or take evidence without a warrant, if the evidence was found in plain view and open to inspection. So here's an example. I respond to a medical emergency at somebody's house. The person is going into a diabetic coma. While I'm there trying to establish or provide medical care, I look over on the living room table in plain view, and there is a bunch of cocaine being cut and bagged, etc., etc. That is evidence that I can take and bag and use against the individual because the illegal conduct was found in plain view. Okay. Common situations where the plain view doctrine is applied: in progress crimes, fires, accidents, medical situations, conducting an inventory impound search of a vehicle. What that means is every one of these incidences where an officer has a legal right to be there, whether they're responding to a medical emergency or a crime in progress or helping somebody put out a fire or pulling people out of a fire, etc., etc., anything that they find that might be criminal activity is legally able to be collected and can be used against a person because it was obtained and found in plain view. No search warrant was necessary. Arrest. In technical terms, an arrest occurs when a law enforcement officer restricts a person's freedom to leave. An officer is not required to yell, "You are under arrest." And Miranda warning is not required, but we'll discuss this in a little bit. Again, I'm just going to let you read through this when I send the PowerPoint. Terry frisks. It's very important you understand the difference between probable cause and reasonable suspicion. A reasonable suspicion is really a belief based on a consideration of facts at hand and on reasonable inferences drawn from those facts that would induce an ordinary, prudent, and cautious person, under the same circumstances, to conclude that criminal activity is taking place or that it had recently occurred. So I could go and pat down somebody who appears suspicious, who looks like they're casing a jewelry store late at night, and I don't need probable cause for that, for a Terry stop or a Terry frisk. All I need is reasonable suspicion. Now listen, this is coming up on 15 minutes, so I'm going to stop here and we'll go through part 3 soon, and that will finish off chapter 5 and all of chapter 6.